Hello, everybody. Thought I'd talk about orders for a second. Orders make the world go round in the legal setting. That is, anytime there's a motion filed or anytime there's a preliminary objection, they generally get resolved by the court deciding it, or the people can agree to an order themselves. But what you'll usually do when you file a motion, not usually, what you'll always do when you file a motion or you file a preliminary objection, you'll include an order that you would like the court to sign. So you prepare the order and it gets submitted with the rest of your paperwork, whether it be a motion or a preliminary objection. And the hope is that that proposed order will be the one that the judge signs. Sometimes it will lead to further disputes. The opposition, the people on the other side may feel like your motion doesn't permit the relief that you're asking for. Sometimes the court won't agree with the order and you may have to change it, but it usually gives the other side a good idea of exactly what you're looking for. So what's happened is, in the case of Butler versus McCoy, is that McCoy and the rest of the defendant's attorneys have filed a preliminary objection, and interestingly enough, they raised four different points. One was the civil conspiracy claim. If you recall, that was count 2. If you recall, count 3, the intentional infliction of emotional distress count. And additionally, they asked for punitive damages and they asked for attorney's fees. I'll address a couple of those points if I may. First, with respect to punitive damages, remember I mentioned that really only is allowed, in my experience, in extraordinary circumstances. And the same would be true with intentional infliction of emotional distress. Further, when they ask for attorney's fees, there's an American rule, what we call the American rule. The American rule is that each side generally will pay their own attorney's fees unless there is either an agreement that governs attorney's fees between the party, or there's a statute that provides how attorney's fees may be paid. But generally the American rule is you pay your own attorney's fees, not the other side's, even if you win. But there are exceptions to that. The British rule is winners can have their attorney's fees paid. Additionally, there's language in here that I wanted you to understand. If you look to subparagraph 1, the civil conspiracy claim contained in count 2 of the complaint is hereby dismissed with prejudice. When we call something dismissed with prejudice, that means that it can never be brought again. It is completely barred. I believe we'd seen something somewhere that something was dismissed without prejudice. If something is dismissed without prejudice, it's still alive and can be brought back if somebody wants to. But with prejudice means it's done. But this format, if you look at it, this spot where it says, and now this blank, the judge would fill that in on the date, and at the very bottom, it states signed. That's where the judge would indicate their signature, and that's your court order. That would be powerful stuff. If the judge signs this, then all those items will be dealt with. So much for orders. They're an important part of everything. They're, I guess at this point, when it's not signed yet, it would be a proposed order. And that sort of thing will accompany any motion or any preliminary objection you make. I'm not going to say any more about it. Thanks again for listening.